So the two labs I'm going to be talking about are the Department of Public Safety Crime Lab in Houston and the Houston Forensic Science Center. In 2015, a DNA analyst gave what is considered false testimony in court. The unnamed analyst did so by omitting important information about the condition the evidence was received in. The analyst worked for the Department of Public Safety Crime Lab in Houston when the evidence examination occurred, which was back in 2013. At that time, the analyst was a forensic biology screener and did not complete the DNA analysis in question, but only prepared the evidence for the next analyst who would be completing the DNA analysis. This analyst then left the DPS lab to work for the Houston Forensic Science Center in Houston, and this is actually where he became a DNA analyst. Now, it's unclear when he actually moved to the Houston Forensic Science Center. However, by May of 2017, when the trial began, the analyst was already working at the Houston Forensic Science Center. Then, after a result of this violation, he was fired from the Houston Forensic Science Center in May of 2022. The self-disclosure was what started the whole violation process. On April 7, 2022, HFSC released a self-disclosure regarding the testimony made by the analyst in question. Then, June 7, 2022, DPS submitted their own quality incident report to investigate the allegations. Now, remember, the analyst was working at HFSC at the time, but the testimony that was brought into question was when he was working for DPS. Then, September 6, 2022, DPS submitted a supplemental QIR, which is a quality incident report addressing the concerns related to possible DNA degradation or contamination. The quality incident report number QI-HOU-2022-0321-DNA. Now, this report was created by the Texas Department of Public Safety Crime Lab. It was discovered on March 21st, 2022. Now, the QIR was related to a policy, procedure, or specification violation relating to these two. The incident description that occurred on October 1st, 2013, a styrofoam cooler was received by the DPS Crime Lab with the label "Refrigerate upon arrival." Unfortunately, this cooler was not stored refrigerated and was actually placed upon a shelf. Then, on October 31st of the same year, 30 days later, the cooler was pulled off that unrefrigerated shelf for examination by the analyst in question. Now, this was the first time that any evidence inside that cooler was examined. The cooler, once opened by the analyst, was found to have melted ice packs inside it, as well as a foul-smelling liquid on the bottom of the cooler, and a FedEx envelope that was wet and soggy. All of this he did document in his laboratory notes. At this time, no supervisors were made aware of the condition of the evidence when the examination of the evidence was removed from the cooler. So only the analyst in question had knowledge of what the evidence appeared like when it first came to the DPS lab. So the action plan or supplement plan put in place by the Texas Department of Public Safety Crime Lab, labeled QI-HOU-2022-0321-DNA. So the areas to be addressed in the action plan were documentation and risk assessment. So the lab has incorporated a more well-defined practice regarding the handling and receipt of compromised evidence, the expectations regarding documentation when something of this happens again, the notification of quality issues to supervisors or technical leaders in the laboratory, and the lab has also added dedicated quality managers for each lab to oversee the implementation, training, and daily management of any quality-related activities. A lab manager has met with the evidence technicians to reiterate the importance of attention to detail related to proper evidence and storage conditions. While this has been an action plan for DPS Crime Lab, it is also something that the Houston Forensic Science Center is also implementing in their own lab. So the violation was that the analyst gave false testimony while under oath. So the analyst was unfamiliar with the case. He testified in 2017, and the evidence had been analyzed in 2013. However, at the time he testified, he had not reviewed any notes based on this case, nor did he have any information about what the case was even about. So the analyst was found to have committed professional negligence in failing to prepare adequately for trial. Now, this occurred due to the fact that he was answering questions based purely on memory on the examination he did in 2013. So some of the questions that were asked were asking for specific answers, yet he answered these with complete confidence when he could not have possibly remembered all of the details of what had happened 4 years prior. One of the questions asked by the defense attorney was if there was anything wrong when the evidence was received. At the time, the analyst simply replied that if there was anything wrong with the evidence, he would have notated it in his notes. And since the defense attorney did not mention any discrepancies in his notes, he said there couldn't have been anything wrong. A kind of circular argument, basically stating you did not see anything there, so there was nothing there that was wrong. Consequences of his actions. Unfortunately, the criminal justice system lost faith in this analyst, and several police departments were also not wanting to work with any labs where he was performing any DNA analysis. So because of that, he was asked not to work on any further cases until the investigation into what had happened concluded. Because of his actions, any cases that he worked on in the past while working at the DPS lab and the Houston Forensic Science Lab also are coming into question and may possibly need to be reanalyzed. Now, this equates to about 400 possible DNA cases in Harris County. At this time, there is a backlog of DNA cases of about 6 months. So the case in question, the suspect was convicted of capital murder while the prosecution was seeking the death penalty. 2 females were allegedly murdered by the suspect. And since then, the case has been overturned since the suspect has been given the writ of habeas corpus. So how do both quality assurance and quality control relate to this violation? While quality control focuses more on following procedures, methods, and any steps necessary to complete evidence analysis accurately and credibly, it talks more about following the steps necessary to make sure that the tests are run correctly. Quality assurance, on the other hand, is the training, planning, and procedures that are in place to make sure all analysts are working at their best to assure nonconformities do not occur. This is that plan that they have in place just in case something like this happens. Who should they talk to, or who should he have talked to make sure that the evidence was in good standing and not contaminated in any way so that it could be used in court. So let's talk a little bit about the audit process and recertification. Now, the audit process is basically there to verify that the labs are in compliance with all standards. Often, guest auditors with subject experience will review lab procedures along with cases to determine if any nonconformances had occurred. Now, they will have these technical advisors that have experience in each section of the lab that they are auditing. That way they know what they are doing and what should be occurring in each lab. After the audit is complete, any nonconformances will be explained along with any suggestions for improvement for that lab. So recertification is when a lab has basically received sanctions and are no longer considered accredited. So once sanctions are in place, that lab will have approximately 30 days to document and submit a plan to identify any corrective actions, explain how the actions will be implemented, and provide a timescale for completion. Once all of the sanctions have been satisfied, then the lab could go ahead and go through the process of recertification.